Everybody, I wanted to welcome you to today's webinar, Building an Effective Background Screening Program. My name is Sarah Van Gilder, and I'm the Marketing Manager here at Corporate Screening Services. We're pleased to be able to present this webinar to you today, and we hope that you get a lot of information from it. Just a little bit of housekeeping to begin. I wanted to let you know that you're going to be muted throughout the webinar, but if you do have any questions, all you need to do is type it up and send it to me via the question screen. Just go ahead and type your question in the question box and hit send. And I'll be monitoring questions throughout the presentation. And if there's anything that needs to be addressed immediately, I'll ask it. Otherwise, I'm going to hold it until the end of the presentation when we have a question and answer period, and we'll get to all of the questions then. So at this time, I'd like to take a moment to introduce you to our presenter, Matt Jay. Matt's been a member of the corporate screening team for over 16 years, and he's one of the industry's leading experts on pre-employment student background screening. As Vice President of Sales, he currently leads corporate screening's business development efforts. Matt has been a key player in identifying and developing products and services to better serve corporate screening's clients, which includes top employers and educational institutions throughout the nation, as well as here in Ohio. Matt is a member of the National Association of Professional Background Screeners, also known as NAPBS, of which corporate screening is an accredited member. And at this time, I'm going to go ahead and turn the webinar over to him. Matt, it's all yours.
All right. Thanks so much, Sarah, and thank you to everyone who's taken the time to join us today. We really appreciate it, and we're looking forward to sharing with you some best practices on building and maintaining an effective background screening program. Just a little bit of information on what we're going to cover today. I noticed several of the folks joining the call are customers of ours, and then there's also quite a few new faces. So we'll provide a little bit of information on who we are at Corporate Screening, a little bit about our background. We're also going to talk about the industry landscape as a whole as it relates to background screening, both for background screening companies and employers. And we'll spend some time on compliance as well. Compliance is definitely a key component of having an effective background screening program. We'll talk in depth about some products and things to consider when you're building out your packages and programs. Spend a little bit of time on some trends and technology, and then we'll close with some Q&A. So as Sarah had mentioned, as we're going through the presentation today, if you have any questions, please be sure to use that messaging module in the right-hand side of your screen, and we'll address all the questions at the end. So with that, we'll go ahead and dive right in. A little bit about our company. We've been in business since 1987. This is our 30th year in business. Our headquarters are in Cleveland, Ohio, and we also have satellite offices in Tampa, Florida, which happens to be where I'm located, Alexandria, Virginia, as well as Charlotte, North Carolina. We are also a founding and accredited member of the NAPBS. For those of you who aren't familiar, that stands for National Association of Professional Background Screeners. And it's definitely a benchmark that you want to look for in any provider that you're working with. It essentially demonstrates that they're meeting the standards of the industry and that they've actually gone through a robust accreditation process to prove that as well. So getting into industry landscape and some compliance information. It's probably no secret to anybody that background screening is a super highly regulated industry. It's also a very large industry. It's about a $3 billion a year domestic industry. And there's several different agencies that have their hand in pre-employment background screening, including the Consumer Financial Protection Bureau, the Federal Trade Commission, even the EEOC in some respects. So there's a lot of eyes out there watching, and it's not just that they're watching the background screening companies, which they are, but they're also watching employers and making sure that employers are doing the things that they should be doing to maintain a compliant program. In 2012, this is the most recent data that we had from SHRM, but SHRM reported 86% of companies that responded are conducting criminal background checks. I'd imagine that that number is probably right around there still to this day, if not a little bit higher. It really has become the norm for most organizations to conduct a background check. Unfortunately, the industry lacks a lot of formal standardization. Even the names of products or services might differ from one vendor to the next. So it can make it a little bit difficult for a client or employer to really know exactly what they're getting. And it's super important that you have a thorough understanding of exactly what your program consists of, so that if there are any gaps, you're aware of those. If you're doing things you don't need to be doing, you're aware of that as well, perhaps saving the organization some money. So we'll talk a little bit more about that later on. Right now I want to jump into some compliance information though. Over the past several years, we've seen a exponential trend in the increase of background screening related litigation. Most of that has to do with Fair Credit Reporting Act violations. And you'll see some numbers here, but of those cases that we're focused on, 67% of them accuse the employer of either violating disclosure and authorization requirements or adverse action requirements, which are some requirements that all employers who conduct background screening have to follow. We talk to a lot of companies day in and day out, and we're consistently surprised at how many companies unintentionally find themselves out of compliance. And it's not just small organizations, there's large ones as well. Background screening companies or consumer reporting agencies, CRAs, are also being targeted with accusations that they're not providing information that's complete and up to date, and that can be problematic as well. So again, when we get a little bit deeper into the content of today's presentation, we'll talk about how not all background screening products are the same. It's important to understand how specific searches are conducted, that you're getting quality information, that it's coming from the right source, just to ensure that you're in compliance. So I mentioned some large companies earlier that have seen themselves in the face of litigation, whether it be from the Fair Credit Reporting Act or the EEOC. You can guess what all these companies on the list here have in common. These cases are extremely expensive. Even if you're not found in the wrong, just to have to litigate it can easily be six figures. We see a lot of attorneys that they see this as kind of a ripe area to make a lot of money because it's very easy as an employer to have a technical violation. That means that it could be something as simple as language in your disclosure wasn't exactly the way it should be, and somebody decides to sue you, or worse, they band together as a class action and they try to sue you that way. Damages can be between $100 to $1,000 per violation, and that's not taking into account attorney fees and other damages, and that could apply even if no harm was caused. So what I mean by that is you could have still hired that individual, but because something was out of sorts and they sued you, it's still going to end up costing you money. So can't stress enough dotting the I's and crossing the T's, making sure that you're up to speed with everything that you should be. A couple of just pieces of evidence here. 2014, Publix, they settled an FCRA lawsuit for almost $7 million. Wells Fargo, even before all the trouble that they're having today, they had to pay $12 million. And the list just goes on and on and on. I mean, we've got Home Depot, Chuck E. Cheese, Food Lion. Almost all of these cases are in the seven figures. Calvin Klein was six figures, but still pretty costly for any employer. So I think one of the lessons to learn here is if these large organizations with a lot of resources are struggling to get it right, what about a mid-sized company or smaller company that may not have all those resources? That's why it's important, whoever you work with to handle your background screening, it should truly be a partnership. You guys should be working in conjunction with one another. It should be an involved process and something that isn't just left at the point of sale. These are things that should really be reviewed on a pretty regular basis. So you want to actively engage in that process and make sure that you're keeping yourself in the clear. I mentioned earlier what some of these lawsuits typically have to deal with. Disclosure and authorizations. I mentioned the adverse action procedure. So I want to talk a little bit about what is it specifically that you need to do. And we just recently hosted about a month or so ago a compliance webinar that went into this in a lot more detail. We covered some of the state-specific aspects. So what I'm going to cover today is going to be a little bit more high level and in compliance with federal law. But bear in mind, you may be in an area where there's some additional state-specific requirements that could add more restrictions onto you. So definitely something you should talk about with your provider and make sure that you're doing everything correctly. So the first thing here is you have to tell the candidate that you're going to be conducting a background check. And that disclosure to them has to be done in writing. The authorization portion, that can be a part of the disclosure, or it can be a separate document. Either one is fine, but it has to be done before the background check is requested. If there's state-specific requirements that apply, you want to include those as well prior to the background check being requested, and you always want to make sure that you're maintaining a copy of that original signed document. In the event that you're ever audited or you're sued, you're going to have a copy of that. In addition to the disclosure and the authorization, you also have to provide the candidate with a summary of their rights under the Federal Fair Credit Reporting Act. So sometimes people will say, well, it's the Fair Credit Reporting Act. That doesn't apply because we're not requesting credit reports. The Fair Credit Reporting Act, it actually applies to all form of consumer report, which basically means anytime you engage a third party to provide your organization with a background check, that's a consumer report, and it's governed under the Fair Credit Reporting Act. But those are basically the only requirements that you have to worry about on the front end. So disclosure and authorization. If you're in a place where there's state-specific notices that have to go out, you want to make sure you provide those, and then a summary of rights. Now, on the back end, if everything checks out in the background check and there's no issue, there really aren't a whole lot of requirements that you have to contend with as an employer. However, if that background check revealed something that you perceive to be derogatory, and because of that, you're going to take some form of adverse action. This doesn't even just apply to new hires. Obviously, failing to hire somebody because of a background check would be an adverse action. But even an existing employee, if you don't retain them because you did let's say an update background check, or you were going to promote them and you did a background check before you did that, or before you relocated them, any action that you take that could be construed as being adverse to the individual, you have to follow these procedures. It's also important to know that you want to advocate for the candidate, as do we. So these procedures are really designed not just to protect you and the background screening company, but also your candidate. There could be instances where there is an error in the report, and generally that's not the fault of your background screening company or the applicant. It could be the court where the information was pulled from didn't accurately update something, and that caused an issue. So by following these procedures, you're actually allowing the candidate the ability to dispute the information contained in the report before you actually take that adverse action against them. So the adverse action process itself, it consists of two different parts. The first part is what we call pre-adverse action, which is essentially a letter that goes out to the candidate letting them know a background check was conducted, what their rights are, including the ability to dispute the background check if they feel that something's inaccurate. But at this stage, we're not actually telling the candidate that they're being denied employment, because we want to allow them the ability to dispute before we take that action. So that's extremely important. The second step of the process is you have to allow an adequate amount of time, that's generally considered 5 business days, to elapse before you take that action. The reason being is you need to give the candidate enough time to view the report and make the decision of whether they're going to dispute it or not. If they don't choose to dispute the report, then you would follow up with that second letter 5 days later. If they do choose to dispute the report, then your background screening provider will initiate a reinvestigation immediately. If anything needs to be updated, they'll provide you with the information relative to that. But that's the compliance steps in a nutshell under federal law anyway. So some things I want to review in closing before we jump ahead any further as it relates to compliance are, you should have a company background screening policy in place. You should seek legal review of that policy. It's also something that shouldn't be set up and then forgotten about. You should really review that on an annual basis. From the Fair Credit Reporting Act perspective, you want to make sure that you have all your ducks in a row with documents and procedures. You also want to take into account other things like how you use a background check to make your decision. There's EEOC considerations that need to be taken into account. It should really be done on an individualized basis, not a flat across the board, you fail if this happens. And then there's other things that you want to be on the lookout for. Ban in the box is spreading rapidly across the country. You want to make sure that your employment applications are up to date. If you need to remove questions relating to criminal history, you want to make sure that you're good on that. And if you're among organizations that are using credit report information, you should take a close look at that as well. There are parts of the country that are enacting legislation that severely restricts an employer's ability to conduct a pre-employment credit report, and there's very few exceptions in those areas to when you can or can't, when you can run a credit report. So now we're going to dig a little bit more into how you actually establish your background screening program, as well as how you maintain it, including ensuring that you've got the right types of products and services and instructions in place. Obviously, the reason that an employer implements a background screening program is because they want to mitigate the risk associated with a bad hire or placement. You know, the statistics are out there. It shows what a bad hire or placement can cost an organization, and that can be pretty staggering. But sometimes the term background screening, it gets used kind of universally, and that's not right, because not all background screening reports contain the same information. There's a lot of difference in terminology. You know, a criminal record search is a very broad-based term. It's more of an umbrella, and under a criminal record search, there's a bunch of different types of criminal record searches that are available. You should also keep in mind the industry that you're in, the risks that your specific organization has, and use that as a determining factor in how you build your program. It should really be customized to the specific needs of your organization, even to have multiple packages dependent on the different layers of hiring that you're doing. You know, an entry-level position may not have the same rigorous requirements that somebody in management or a financial position would have. And obviously not all background screening vendors are alike. I talked a little bit earlier about that NAPBS accreditation and that being a benchmark to look for, but that's really not the only thing. You want to look at how your account's going to be serviced. You want to look at different convenience factors. For example, when you order the background checks, do you want to be the one doing the data entry, or would it be better for your process if you uploaded the order and the vendor did the data entry for you? Or if you're using an applicant tracking system, do you want the background screening program to integrate with that to make it a little bit easier for you? Some other considerations to think about are instructions. So you're doing a criminal record search. That's great. But what are the instructions on it? Are you only checking the person's current name, current jurisdiction of residence, or do you follow more of a best practice where you're checking all names and all counties of residence? Some other considerations to think about are non-employee workforce. So that would be contractors that come into your facility, volunteers, in some instances students. We do a lot of work with student background screening, and those institutions that we work with, those schools, they need to make sure that their background check is in compliance with the requirements of their clinical partner, because they're going to be sending folks out to hospitals, and the hospital might have a particular standard of background check that they need to follow. So if you're in an area like that where you're contractually bound to do a specific type of background check, you want to make sure your vendor is doing that right to the T. Otherwise, if you get audited and there's some sort of issue and it's found to be out of compliance, that could be super problematic for the organization. I'm going to talk a little bit about some of the core components of a background screening program. There are literally hundreds of different search products that are out there. So for sake of brevity, we're not going to cover every single type of search product, but I'm going to cover some of the more common ones that oftentimes are a little bit misunderstood. So one of those key components to a background check is what we call a social security number, trace, and validation. And what this does for us is it really acts as an investigative tool so that we can figure out what names your candidate have used and what their address history is. What they self-disclose to you is really only part of the picture. If you have a candidate that's savvy and they've been convicted under another name or it happened in an area that they don't currently live in, and they don't want you to find out about that, the first thing that they're going to do is they're not going to disclose that name on the employment application. They're not going to disclose the location where that occurred in the hopes that you don't check for it. So a good program is going to really be a bit of a cross-reference between what the candidate has self-supplied and then what comes up on the social security number trace. Best practice programs are going to check all of those names as well as all of those jurisdictions of residence. And for those of you who aren't familiar, the way that this information gets obtained is when you do different things like apply for credit or news or magazine subscriptions or utilities, your information gets bought and sold and packaged in a number of different ways. We think of it as being kind of an electronic footprint. So if you think about the trace as being a collection of those electronic footprints, it's really a pretty critical part of an effective background check program. Then what we're doing from there, or what should be done in a solid program, is we're taking that information from the application, we're taking that information from the trace, and then we're running different types of searches based on that. So when it comes to criminal record checks, for example, there's a couple of different types that can be run. What we generally recommend as a part of any good program are primary source court searches. So examples of primary source would be state jurisdictional courts, often referred to as county courts, and those are going to provide you with information relative to a violation of state law. And we have federal courts as well. We'll get into a little bit more detail on that later. But right now what I want to focus on, though, is the difference between primary source and non-primary source. So primary source, as the name implies, means it's coming straight from the horse's mouth, so to speak. We're going directly to the court of record to obtain that information. So what that's going to do for you is ensure consistency across the country with coverage. It's also going to give you the most accurate and most up-to-date information available because it's not coming from like an aggregate database. You're never going to find information more up-to-date, more reliable than directly from the court itself. And it's also completely compliant with Fair Credit Reporting Act and the EEOC. Because we're getting the most accurate and up-to-date information possible, which is essentially what the FCRA says you have to do, there's no gray area there. An item to consider, though, not necessarily a negative, but just something to be aware of, is jurisdictional courts or primary source courts. They are limited geographically to where that court's located. So if you have somebody in multiple counties, to do an effective search, you need to check each county. It's not a one search covers everywhere type of situation. But the trace is a great tool to determine what locations and what names should be checked as part of the program. So that covers the primary source courts. Now, the next item that I want to talk about is database searches. These are often pretty misunderstood. And part of it is they come with terminology that says national and things like that that would lead you to believe it's all-inclusive. That's not necessarily the case. I'll start with some of the pros of database searches, and then we'll talk about some things to consider. I want to lead off with database searches can be a great tool, but they really shouldn't be used as a standalone, and for the reasons I mentioned before with the benefit of primary source court searches. But one of the major benefits of a database is it has large geographic coverage, and there's several million records that are a part of the national criminal databases. You also get results back pretty quick. But again, it should really be used as a supplement to those primary court searches. It's kind of like a safety net to help uncover things that may be outside of a person's area of residence. Nothing's 100%, but it gives you a good supplemental tool. Now, some things to consider with these databases are they're not always totally accurate. Sometimes the database is relying on old, antiquated information. Something changes at the court, like an expungement or dismissal or something like that, and it doesn't get updated in the database. It can also have incomplete information, so arrest without conviction, things like that. You have to be really, really careful with these. They can be done, but they have to be done in a specific way in order to maintain compliance, meaning if there's hits that are found, they have to be properly identified with the subject of the background check. If a hit's found, the background screening vendor should be going to the primary source where the hit came up in the database and re-verifying it to make sure that everything is accurate, up to date, and it's good to go, ensuring you're compliant. So you really want to be careful just so that you don't have a false sense of security. If you're running a national database only, it's probably a good idea to take a deeper look at your program and determine if it would make sense to maybe augment it a little bit and make some changes. Now, I've included here some of the specific products. I alluded to them earlier, and I'm going to cover them in a little bit more detail here. This, again, is just so important because the term criminal record search gets thrown around quite a bit, and it's kind of generic. You really need to understand the layers that fall within that scope. So county court searches are generally considered the gold standard. If you're going to do criminal record searches as part of a program and you're going to pick one type only to do, this is generally the go-to. It's going to be checking for convictions relating to violation of individual state law. It's done on a county-by-county basis. It's the most up-to-date information that you can get. But what you need to make sure is being done is when those searches are run, that your vendor has solid quality assurance procedures in place. For example, if we get a hit on a criminal record, we're looking to match it with 3 personal identifiers so that we know it's your person before that report ends up on your desk. Another thing that we want to do is look at the information that comes back from the court, and instead of just providing you with that raw data, we want to look at it and see if there's any restrictions. There are certain states that have prohibitions on how far back information can be reported. California is a great example. There's a 7-year rule on convictions in California, and even more finite is marijuana-related convictions. There's a 2-year rule on those. So one of the things that we'll do is we'll look and we'll compare our findings with the applicable federal or state reporting restrictions, and we're only going to report back what can legally be used. So that's an extremely important part of making sure your program's compliant, because if your vendor reports back something to you that you shouldn't have had, the liability for that may very well fall on your shoulders and not your vendors. Federal court searches, the QA procedures are very similar to county courts, basically identical in terms of identifiers and reporting restrictions. The main difference is we're checking for violations of federal law here. So that's an important distinction. If your candidate was convicted under federal law and it was handled at the federal court and you're only checking county courts, you're never going to find that conviction. So you want to think about that with your program and determine, hey, is it important to us if somebody's been convicted at the federal courts that we know that information? That's something that's often overlooked. And then the last item I have here in terms of the court searches would be the National Criminal Search. The product name that we use for ours, it's called Crime Sweep National, but they go under different monikers depending on who you're using. Again, this is one of those things where they're not all alike. The biggest differentiator and what you want to make sure you have in place is that it's being re-verified at the primary source. So if a hit's found in that database, for example, if you're getting results back instantaneously right now, it's not being checked the way it should be. That should be a red flag. Particularly if you're getting hit information back and it hasn't been re-verified, that's a major red flag. It should always get re-verified at the primary source. It should get matched up with the right identifiers. That's something we've seen a lot of companies get in trouble for. They use these database results and the vendor's reporting it back to them without properly identifying it. It turns out it's not even the person, they get denied employment, and it can be just a giant mess for an organization. So that covers the primary court searches or criminal record searches. As I mentioned earlier, there's a litany of different types of products out there, but I want to focus on some of the major ones today. If anyone on the call has specific questions about other products or services and you'd like to talk privately after the call, we're happy to set up a discussion as well. I'm going to cover some other verification products because these are often components that we include or that our clients require as part of the background check program, and there's some really important things to look for here as well. For example, when an employment verification is being conducted for you, you've got the employment application, right? A candidate has listed on the application a supervisor name and probably a phone number for the company, and that's all well and good, but we have no idea if that phone number goes back to that company or not. So we're not just going to blindly pick up the phone and dial that number because it could be a friend of the candidate, a relative. It could even be the candidate. The information for an employment verification should really only be obtained from authorized and qualified sources. So that would be payroll, human resources. We're going to independently vet those numbers and go directly to those sources as opposed to relying on what the candidate supplies. You might get it back quicker that way, but you want to pay for quality and not, just a quick turnaround time that could very well not even be legitimate. The other thing that you want to watch out for is ensuring that multiple attempts are being made to get the employment verification, and it's just not getting bailed out after 3 attempts because you're going to end up with incomplete reports. And frankly, it's something that you're paying for. You should get as complete of a result as possible. Lastly, as it relates to employment verification, if there's any derogatory or discrepant information, like the person was terminated, they're not eligible for rehire, things like that, you want to obtain that information in writing. That way, if it's ever challenged by the source of the information, you have documentation to back it up. So that's a step that we incorporate in our quality processes. With education verification, very similar. You want to make sure that the information is coming from a qualified source. Depending on the type of school, it could be a registrar's office, a records office, Board of Education, what have you. Sometimes with high schools, records can be difficult to track down. You want to make sure that the vendor is looking to follow those records. If they've merged with another district or they're held somewhere else, they're going after that information. And then also, diploma mills are a huge trend with education, where a candidate lists a college, it looks to be legit, but in fact they're not really nationally accredited. It's kind of a situation with pay $500 and we'll send you a degree based on your life experience. You want to make sure that those are being ferreted out. It's amazing. If you go on LinkedIn and you type in the name of a diploma mill, like one that's pretty prevalent is Alameda University, you'll see a ton of people that proudly proclaim that as their source of education. So people are pretty brazen in doing this sort of thing. Another thing that I want to make note of, I don't have a bullet on the screen for it, but when it comes to documentation, if a candidate presents you with a copy of their diploma or a W-2 or something like that, you don't want to accept that at face value. You really want to partner with your background screening company to validate that. I can't tell you how many times we get a copy of a diploma from a candidate or a W-2, and we contact the school or we contact the employer, and they can tell spot on that it's falsified. It happens all the time. So just be mindful of that. It's pretty important. The last item I had here under verifications, was professional license, credentials, things like that. Those should all also be verified primary source. If somebody provides you a copy of their professional license, that's not going to be good enough. Needs to make sure it's coming right from the source. There could have been disciplinary action taken against the license. You want to make sure that it's truly active, there's no actions against it, those sort of things. And then again, anything that's discrepant, you also want to make sure that that's being obtained in writing. So another huge item is trends in technology. And if you all have a pen and paper handy, if you mark down this date and time, May 10th at 2 p.m., we're going to be hosting a more in-depth webinar that's specifically going to focus on various ordering options and also integration capabilities. So I definitely encourage anyone who's either considering an integration with an ATS or maybe looking for a more efficient way of ordering and receiving background check results to sign up for that webinar. It's going to be a great event. I'm going to cover it more at a high level for today. ATS and HRIS integrations are huge in our industry. Practically every week we're working on a new integration for either an existing customer or a new customer that we're bringing on board. So the usage of these systems is huge. At a high level, it allows you to order and receive background check reports directly through your ATS system of choice. It reduces the overall time spent in the background screening process. So if you haven't considered an integration and you're using an ATS, it's something that we definitely encourage you to look at. Also, depending on how it's configured and the workflows, it can help you with compliance, like ensuring the authorizations are always signed before the background check's initiated, and nothing's done out of the correct order. Some other technology trends are candidate invitation orders. So whereas maybe historically you were used to going into a vendor site and doing the data entry yourself or having the vendor do it for you, a lot of clients are now embracing sending out an email invitation to the candidate that allows them to do the data entry themselves. Engages with the candidates a little bit more. It also minimizes the need for clients to collect personally identifiable information like dates of birth and social security numbers. From a discrimination standpoint, you may not want to have that this early on in the process. So just a couple of things to think about there. And then the last item for technology that I have is drug screening, paperless drug screening. It's something that's been around for a little while, but not everyone takes advantage of it. There's still a lot of folks out there that are using these multi-page lab slip type chain of custody forms. The newer technology allows for a completely paperless process. Your candidate can get the chain of custody form electronically on their iPhone or Android device. As a client, you can determine how long they have to go and get that drug test done, so they're not waiting weeks and weeks and weeks. It could be limited to like 2 to 3 days if you wanted it to be. And then it also provides you with access to a tremendous number of collection sites across the country. So just a few technology trends that we see as being pretty popular right now. And we're getting near the end. I want to just close out with some final thoughts before we start discussing some of the questions that have come in. One of the most important things that you can do with your program is take a deep dive in an evaluation. Partner with the right company that's going to sit down with you, ask the right questions, understand your unique needs, whether they be industry-driven or contracts-driven or what have you, and then design a program that's customized to those needs. Most organizations shouldn't be going with just a boilerplate background check package. It should really be tailored to the needs of the organization, right down to the instructions. You also want to make sure that the process and the workflow that you have works best for your organization. An online ordering method may work great for one company, but candidate invite ordering works better for another, or an ATS integration. So it's important to understand how it's going to fit with your company, your culture, what's going to work best for you. The third bullet here, this one I can't stress enough because we have these conversations so frequently where we see people getting caught in a non-compliant situation. Regularly review your hiring processes, your procedures, the forms that you're using. Take a close look at where you're operating out of. If you have offices that are spread across the country, the requirements aren't going to be the same everywhere, so you want to make sure you're covered. As it relates to a non-employee workforce, if you're doing background checks on your own employees and you have contractors that are coming in, whether they be temps or 1099 or what have you, it's really, really important to make sure that those folks are adhering to the same stringent requirements that you have. Because if you just tell them, hey, we just need you to get a background check, generally they're going to go for a less robust option because they weren't informed of the specific needs that you had. Review this on a regular basis. And obviously, I'd be remiss if I didn't say, select a qualified screening partner. There's a lot of companies out there. By our count, there's roughly 1,000 background check companies in the U.S. It's a pretty saturated industry. You know, as with any industry, you got some good apples, you got some bad ones. Make sure you're picking a good one. So at this time, I'm going to turn things back over to Sarah. She's been moderating the questions as they've come in, and I thank everyone for their time.
Thank you, Matt. And I wanted to take a moment and thank everybody who is here on the webinar and remind you that if you do have a question about any of the topics in today's presentation, just go ahead and type it into the question box and I'll get to it. Real quick, you'll get a follow-up email message after this webinar. It's going to contain a link to a PDF of these slides, and so you'll be able to get a copy of the slides. And if you do have any questions, it's going to have Matt's contact information in it, and our as well as our customer service contact information if you would like to send us any questions. Also, if you do want to contact Matt directly, his information is right there in front of you on the screen, and you can email him at mjjaye@corporatescreening.com or call him directly, 800-229-8606. His extension is 326. So I'm going to go ahead, and I've got a few questions to start with, and I do invite you to go ahead and type in your questions. Can you explain why some of the backgrounds are delayed, Matt?
Sure. So delays can happen for a number of different reasons. For example, if you're dealing with court systems, as an example, and you have a candidate with a super common name, like a John Smith, when we go to search those court records, there could be a number of different John Smiths that come up in that initial, what we call an index. And the index doesn't always provide all of the identifying information that we need to determine if it's your person or not. So what is then required is a pull of the file, where we have to actually go through the physical files and the dockets and look for that additional identifying information, like dates of birth, addresses, DL numbers, what have you, anything that we can use to tie it in with your person. So you'll probably find that people with more unique names, when it comes to court searches, will generally have a faster turnaround time than somebody like a John Smith. There could be other issues too. If it's an old file and it's in an archive location at the court, unfortunately we can be placed at the mercy of the institutions we're getting the information from. But those are a couple of examples of where you might see delays.
Great, thank you. I've got another question. It's more of a it's not a compliance question right now. You mentioned that we should not allow a CRA to use the free and out rule. Can you please go over the CS standard employment verification process, and how is it different and or better than the free and out rule?
Sure. So just to kind of recap for everybody, when it comes to employment verification, we see a lot of companies following this, what we call a free and out rule, which basically means the vendor will make 3 attempts to verify an employment, and after those 3 attempts are made, then it's essentially abandoned and you get an incomplete result with something the likes of, we were unable to complete this, we made a bunch of attempts. Placing a cap of 3 it's fairly arbitrary. What we found in our experience, and by the way, we don't place any caps on the number of attempts, we leave it to the analyst who's handling the case to their discretion. But generally speaking, it can oftentimes take more than 3 attempts to get a verification. It's just the way things are. I'm sure the folks on the line here who are in HR, you get a lot of folks contacting you wanting to get employment verifications, and it may not be the first thing on your docket to do. You might not be able to get back to them right away. Same thing with us. When we're contacting companies, we have to be persistent. We have to do smart activity, like staggering our call attempts. You know, if we call every day at noon and they're at lunch, that's not going to do any good. So we want to make sure there's smart activity. If they say, hey, the person you need to talk to is going to be back at 3, there's a mechanism in place for us where we can tag an alarm and then we follow up at 3, so we're not missing that person again. But to answer the question directly, we have no free and out rule. There's no arbitrary cap at all. If we see, after an extensive number of attempts that it's unlikely we're going to get a response, then our analyst will get approval from their supervisor to write that one off as not being able to be verified. But our numbers show us we're very successful after 3 attempts in getting a completed verification.
Thank you, Matt. I've got a question about a product. How can I ensure background checks are running Social Security numbers through all databases and not just the name the client enters, knowing that they could put in a false name, etc.? What product ensures this?
Yeah, great question. So in part, the Social Security number trace that we would run. For example, let's say you've got a candidate and their name is John Smith for sake of simplicity. And John Smith provides a Social Security number. Well, when we go to run our Social Security number trace, we're actually not keying in the name John Smith. What we're doing is we're keying in that Social Security number. And then the result that we get back as part of that investigative tool is it's showing us names. So if we ran that number and it comes back to Susie Johnson, well, that's a red flag for us. So what we're going to do is we're going to alert our client and let them know, hey, we ran the trace on this individual and we've got a bit of a red flag. It's coming back to a completely different individual, and it could be something, as benign as the order was entered with by accident, if it got transposed, and no harm, no foul, we'll rerun the trace under the correct number. Or it could be something more nefarious where they're trying to pull one over. But in any event, the trace is the best tool for that.
Thank you very much. I've got a couple more questions, and I do invite anybody to go ahead and send in your questions. You had mentioned some state-specific restrictions in California. Are there any state-specific restrictions in Ohio on how far back we can go?
There aren't in Ohio, and just to kind of clarify, because there tends to be a little bit of confusion about how far back can I go in a background check. Under the federal law, as long as it's a conviction, there is no limitation. You could go back 30 years. If it's not a conviction, it's limited to 7 years. And then on top of that, what you want to keep in mind is how far back your vendor is actually going. So as an example, when we conduct a court search, we're going to go back as far as that index allows us to. So if we happen to find something that was from 12 years ago, while we may be guaranteeing a 7-year search on everybody, if we come across something that's older than that, as long as it's legally reportable, then it's going to be included in the report. So that's another thing to look at. If convictions outside of 7 years are important to you, what's your vendor doing? Are they strictly limiting your results to only 7 years, or do they go back further?
Thank you, Matt. I've got a follow-up question to the Social Security number. I understand that some of the searches are only done by using names and not confirming Social Security number. Is this true? I want to ensure all traces are thorough. In that case, what product would I need?
Yeah, that's a good question. So the trace is just one component of the background check, and that trace is run using a Social Security number. Like I said a moment ago, it then returns back names and addresses that we find to be associated with that Social Security number. And then the best practice from there is essentially to check all of the names and the jurisdictions that were self-supplied by the candidate, meaning on their application, and then also what came up on the trace. Now, when we run court searches, there's a huge misconception that when you check a court record, like a county court or a federal court, that those records can be checked by using the person's Social Security number. They actually cannot be checked that way. So all of the court searches, they have to be done based on name. That's why it's so important. If your person went by another name and you're not checking the other name and they got convicted under the other name, then you run a risk of finding that conviction. So all court searches have to be run by name, and you want to make sure you're checking all of the names.
Thanks, Matt. I've got one other question. I do invite you, if you've got any questions, to go ahead and ask them. If not, we'll wrap it up after this. Is there specific language that we have to use in our disclosure or authorization forms?
There is specific language that should be included in there. We provide to all of our clients a compliance packet with some samples of what that language would look like, but you always want to make sure that you're reviewing that with your own legal counsel and using their input to design your forms.
Thank you. And that's it for questions. I'm just going to reiterate one more time how you can contact Matt. You can get in touch with him via email at mjjaye@corporatescreening.com or give him a call at 800-229-8606. His extension is 326. So if you've got any questions, feel free to reach out. And at this time, I didn't get any other questions that came in, so I wanted to thank everybody for attending the webinar, and I wanted to thank you, Matt, as well, for your time in presenting it. Thank you for everybody, and have a great day.